Thank you. Chair Gelser and members of the committee, my name is Annette Smith, and I'm an attorney in Oregon who's appointed to represent children in cases like this. I am a member of the Oregon Criminal Defense Lawyers Association, where I co-chair the juvenile law section. In law school, I focused my energy and educational experiences and work opportunities around juvenile law and around being a voice for children in the courtroom, because that is the issue that I care most about. As an attorney, I've done other things, but my favorite has always been juvenile child welfare cases. I call them dependency cases. I'm an attorney at the Lane County Public Defender's Office in Eugene. I have a high caseload as a public defender, and I currently practice I have cases right now in 3 counties. When I first graduated law school, I started at a law firm in Roseburg and Douglas County, where I practiced dependency law for 5 years. I then moved to Lane County, where I have done this law since October of 2016. I practice in Douglas County, Lane County, Jackson County, and Lincoln County. I am here today to talk about a client of mine that I'm not proud of how long it took me to realize that such a problem was happening in Montana. I try to visit all of my own clients. That's very difficult as an attorney who has a high caseload. And there are a lot of attorneys who do this work who care very much about their clients. A lot of us see our own clients, and a lot of us use visitors to see our clients. As just a personal thing for me in my caseload, I try to see my own clients. This particular client is the first client I've represented who has been sent out of state in a residential placement. I currently have 3 clients out of state. 2 of them are with family, and I have no concerns about those placements. With regard to this child, I'll tell you a little bit of the history of her situation without going into a lot of detail about her personally, because I think that is her privacy. When I first met this client, I was not her first attorney. I was her second attorney. Her first attorney retired. So I took this case over in approximately November of 2017. Around the time I took this case over, she was being placed in a residential facility in Lane County, her county of origin, where she is from. She was at a residential placement treatment facility because she has emotional and behavioral needs. And those behavioral and emotional needs require a high level of care that she was unable to access at home. She spent some time at this facility in Lane County. I visited her there several times. She was then sent to a treatment foster home down in Jackson County. It was considered a TFC, or a treatment foster care home, where she was for approximately a year. That placement disrupted through no fault of this child's, but before this child was quite ready to return home. Because the child didn't have another placement to go, and because she wanted to go home, and because her mom was involved in the case and working hard to get her back, the agency made the decision to do a trial reunification, and she went home to her mother. I was concerned about the case being dismissed at that point, although the agency wanted to. I didn't know that it would last very long, because I think that there was work that my client still needed to do and work that her mother still needed to do to make it work. As my suspicions were correct, the placement with her mother failed within, I believe, 11 days. From there, a series of really sad events happened with her. She was placed in a crisis bed for a period of time. She was placed in a regular foster home in Lane County for a period of time. She was placed in another therapeutic foster home through Oregon Community Programs. She was there for a little while and it didn't work. Her needs were not able to be met in that program. She was also sent to the Albertina Kerr facility in Portland, which was a subacute psychiatric facility. She was there for approximately 2 weeks. She discharged from there back into a regular foster home in Lane County. In between all of those different placements, this was between probably about May of last year and October of last year. At various points, she had to go to the emergency department to stabilize because her behavior would become unmanageable in the home and unsafe. And she was in a regular foster home in Lane County when the decision was being made to place her at an Acadia facility in Butte, Montana. So if there is a committee called the Focus Committee, I certainly, as the child's attorney, was not invited to participate in that committee. My voice is heard. I'm always able to call the caseworker and tell her what I think should happen or what my concerns are. But it felt like in the moment that the decisions about where to put her were more around what was available or what was not available in Oregon. It was not presented as an array of options, and we got to pick the best one. At the point the decision was made to place her in Montana, it felt very much as the child's attorney as the last case scenario, the worst, the last option, because we exhausted all efforts to keep her in Oregon. I can tell you, committee, today that if there's a plan to bring this child back on Monday, that's the first I've heard of that time. I'm not sure what placement they have. I have some ideas, having staffed this case yesterday with some of the folks who are in this room. I'm not sure what bed that is, and I'm looking forward to finding out more information about that. This is my first client who's been placed in a facility like this out of state, and it's been a learning experience for me. And I'm sad that my client had to be on the bad side of that learning experience, because I visited her in December of this year. It did not occur to me to ask a 9-year-old child whether anybody was holding her down and injecting her with medications to calm her down. I checked in with her. I asked her if she felt safe. I asked her how she was doing, and that kind of thing. But it didn't occur to me to ask this child whether anybody was injecting her with medication. I do periodically receive discovery in the case, 193 pages of which I received this morning, which had extensive medical records that I spent some time going through before testifying today. I did not receive information that this child was being injected with anything until my office received the discovery on March 12th. It takes a while for us to process it, gets to me, weekends, things. I learned sometime that week that this child was being injected, not by reading the discovery, which may have mentioned IMs of Benadryl, and I would have had to call someone or know what IMs mean. It turns out IM means intramuscularly. I found out this child was being injected with medication from her mother, and her mother brought that to her attorney's attention, and her attorney brought that to mine. When I received that information, I was horrified and scared for my client's safety, and I called the Acadia facility. Her case manager answered the telephone, and she was able to confirm for me that what I had been told was true, that occasionally my client would be given Benadryl and Vistaril, which are both antihistamines, on top of her regularly prescribed medications. These medications were being offered to her orally, and if she would not take them orally, they were being injected into her body. I've received to this date very inconsistent information about how frequently that was occurring, which medications were being injected into her. I was told by members of from people in this room yesterday that she was only injected with Benadryl. I received records this morning that indicated she was also injected with Vistaril. I don't know what she has been injected with, and it honestly scares me that the records are so inconsistent.
And do you have the same records as DHS? Are these different records than what DHS has?
The records I have, I received from DHS, and so I suspect they are the same. On March 19th, when I called the facility and spoke with the case manager, I asked her to fax me a copy of the medical records to date, all medical records to date for my client, and that fax never came. The information I received from DHS came this morning through discovery, which I think the caseworker sent out yesterday to be processed, to be sent to me. My concerns with this case are great, but my concern in general for these children in Oregon who are being placed out of state is great as well. I want to tell you a little bit about what I have to do to see a child out of state. So if I have a child in state, I can go see them. I can just drive, I can get in my car, work it into my schedule, I can go see them. If I want to see a child, a client of mine out of state, I have to apply for funding to do that through the Office of Public Defense Services. I have to fill out an application that justifies the expense I need covered and why. I have to have my supervisor approve that request for non-routine expenses. I have to send that document into Salem where it is processed by the Office of Public Defense Services, who then approves or denies it. I've never been denied an out-of-state visit. I then receive back a confirmation several days later. I have to contact a travel agency, corporate travel management, through the state with an authorization code given to me by OPDS. I have to book my own hotel room. I have to arrange my own transportation. And other than my plane ticket, I have to do this trip on my own expense and seek reimbursement later. It raises huge concerns for me that if I have a child client out of state that I hear something about, or I have a concern about, or I just want to visit, or I want to talk about their case, that there are huge barriers in the way of me being able to just simply go do that. This particular client has a lot of behavioral and mental health needs, and sometimes she's just not in the mood to talk to me. I would say 60% of the time I go see her, she is super happy to see me and she's glad I'm there to visit. And about 40% of the time she wants nothing to do with me. And I have to say, okay, I understand, I'll come back later. And I do, and I come back several days later. I can't do that when she's in Montana. I can't do that when she's several states away. And that's just a practical barrier for attorneys who represent these children. It cannot be on the child's attorney to be the gatekeeper that protects these children from these kind of things happening to them. I care about all of my clients. I have a lot of clients and I care about all of them, but I cannot be the gatekeeper who is in charge of finding out that these children are being injected, or that they're being held in restraints, or that they're being held in seclusion as punishment. It's on the state to make sure that eyes are on these children. And I'm glad that the agency recognizes that in this case there were failures and that they're admitting to them today, and that we're all going to come up with a plan together to try to fix this situation. My client knows that she's in Montana. She knows that it took her 2 airplanes to get there. She knows that she had to wait in the airport. She knows that she was dropped off there. She also knows that her caseworker hasn't been to see her until today. She's been there since October 23rd. That's a problem. Does the committee have any questions for me?
I do.
Yeah.
Thank you. When it comes to the medical care, and I mean injections as well as, IM injections in particular, and the medication, you need to have a practitioner, a provider. And so have you been able to, and maybe HIPAA is a problem, but been able to talk with their physician to say, why is this child getting these injections? It isn't necessarily DHS's responsibility, it's the provider. And when I'm hearing about what happens at Sequel, they have 24-hour nursing staff and they have a psychiatrist, et cetera. So to me, there seems to be a disconnect with what was happening to this child and the type of medical care that she was getting.
So when I contacted the facility, I ended up talking to her case manager. I didn't actually ask to talk to the doctor. I should do that. And again, this is a learning experience for me. I received records that indicate that a doctor has signed off on at least some of what I can tell from the records that I've received, that when there's an incident, that there is a doctor assigned who signed off on either the use of a hold, the use of seclusion, or the use of emergency medication. So I do believe that there are medical people involved in making those decisions for her. It was difficult for me to get those records. I ended up having to get them from DHS when they told me they would fax me records, and they didn't. I also called to speak with my client on Monday. I left a voicemail, and to this date, as I sit here now, no one has called me back from the facility.
Thank you. Thank you.
Sarah?
Yes, follow up. Representative Hayden.
Thank you, Chair. You mentioned a list, and if you can, and if you can't, I understand, a list of placements for this child. And then the last one you mentioned was that they were in, a foster home in Lane County. What happened? Was there an incident on that last one that they couldn't stay at that one and then went on to Montana? What precipitated that from your perspective?
Yes, Chair Gelser and Representative Hayden, when she was in that foster home, that last foster home before she left for Montana, it was never a plan to keep her there. That was where they had for her to be when she sort of blew out of the Oregon Community Programs foster home. And that it was a holding place for her until a more appropriate bed could be located for her, because she did in fact need a higher level of care than regular foster care.
Thank you.
So first of all, thank you so much for your advocacy for this child. There would not be a difference for her today if you had not been raising these issues. You really were the eyes on for this little girl. And not every kid, unfortunately, gets an attorney in Oregon that has time to be there. And that's a problem. This is the second time in just a couple of weeks where it's an attorney that has a relationship with a child that has really changed a really horrific situation for a kid, and our system should be catching that. But you and I talked a little bit earlier today, and you'd shared a little bit of information with me about kind of seeing some of the incident reports, and I had mentioned earlier about kind of chemical restraint and seclusion and physical restraint for what are kind of childhood behaviors. You have a 9-year-old, I have a 9-year-old. Are you comfortable talking a little bit about that?
A little bit, and I almost said Your Honor, because I'm used to being in court all the time. Chair Gallagher. I want to clarify a little bit. So I don't have information to support the notion that she is getting injected with chemical restraints for what I would consider normal childhood behavior. Her behavior is exceptional. The information that I have received and is consistent with my knowledge of this child is she does have significant behavioral needs. So I don't want the committee to think this kid like throws a pencil at somebody and gets an injection. I don't think that that is what's happening. I think this child does have heightened needs. But I know that they were not being used on her when she was in Oregon. I know that when she was at the therapeutic placement that she started at when I first met her, they were not using any medication on her, maybe melatonin to help her sleep at night. I believe she began medication use when she was in Jackson County. And so if they're at a place where they're saying this child needs this intervention to be successful, I don't understand why. And I don't understand why she has been there for 6 months and they're still needing that level of intervention. And that's not something that was happening to her in Oregon.
But in terms of exceptional, there's exceptional need and there's exceptional need. So in Oregon, the requirement for use of a physical restraint, for instance, would be imminent risk of serious physical injury. Is she, I mean, there's kicking doors and kicking walls and throwing things and talking back and shouting for a long period of time, none of which put people at risk. It is frustrating. And then there is, hitting somebody over the head with a chair or, gouging somebody in the eyes. Where is she?
So that is a difficult question to answer because I'm not there. And I see what the reports say. I see the codes that the reports say. So they'll, 1 is hitting and kicking, a 2 is this, a 3 is that. I see the codes that they're indicating on the incident reports, but I'm not there. I don't know what that behavior is. I don't know if hitting a staff is punching someone in the face or is pushing off. I don't actually know.
Great, thank you. All right, any further questions? All right, thanks. And do we have Dr. Fisher on the phone?
She needs to recall.
She needs to recall. And Dr. Fisher.